Hi, everybody. Welcome back to another episode of Tax Sale Insiders. I am your host today. I'm Brian Seidensticker. I'm the CEO of Tax Sale Resources. With me, I've returning. Matt's been with us several times. Matt Abey with Nelson Mullins, and I guess Nelson Mullins is fairly unique, Matt, in the fact that it provides, I'll say, probably the most in-depth, tax lien legal services in several states. I haven't come across many legal firms that do it as deep as you guys do. But anyhow, Matt, welcome back. Thanks for joining us.
Absolutely.
Well, there's been no shortage of excitement and discussion, revolving around the Tyler Hennepin, Supreme Court case that came out, I guess, last year, and the fallout of that, proceeds, right. And I don't think we'll see the end of that fallout for many years, but the latest topic or hot topic, is this, let's say, the state Supreme Court case in Nebraska. Just a little background on I guess, Tyler Hennepin, for anybody that is listening and going, what are you talking about? And then what, where Nebraska's at, before I hand it over to you, Matt, and take it from there. But, the Tyler Hennepin case, long story short, it was started in Minnesota. The ruling essentially said that it's not okay for a taking, and basically if there is additional equity in the property, that the equity is due to the previous owner. It's not okay for the government to keep it. And then there was this kind of open question of okay, well, what about these states that don't have a mechanism of creating that equity, aka tax deed auctions, because several states have just lien auctions, and then the lien is basically turned into a deed, and what to do here. What was being argued within Nebraska prior to the Tyler Hennepin case, and had moved all the way up to the Supreme Court, was okay, there's equity due to the previous owner. Who owes it, right? And basically the Tyler Hennepin case, as a result of that, Supreme Court, the U.S. Supreme Court pushed it back down to the state and said, okay, can you please review this again? Taking our Tyler Hennepin ruling into account. And it was, basically sat there in limbo waiting for a decision. And that decision finally came out, I guess, a couple weeks ago. But that kind of sets the stage of where we're at. I guess, Matt, what happened and where do we go from here?
Yeah, so the Nebraska Supreme Court on August 23rd issued its opinion in Fair versus Continental Resources. It also issued a second opinion in a companion case, but largely just parroted the opinion in Fair. We're going to see the fallout. We have seen the fallout from Tyler in the past year in a whole variety of states, both in state courts and state legislatures, federal courts interpreting Tyler. But I think we're also going to see a fallout from this opinion in the Nebraska Supreme Court for months and years to come as well. This is a big one for the industry, and it has some implications that those in the industry really need to take seriously. Fortunately, the opinion out of the Supreme Court of Nebraska applies just in Nebraska. So technically, it does not control tax sales or lien sales in other states, Arizona, Alabama, New Jersey, Michigan, elsewhere. But I do think we need to be concerned about other state courts potentially adopting this reasoning. And so that's why I think it's important that we walk through exactly what the case does, and how you might be able to distinguish this case if you are doing some sort of quiet title, or you're doing a lien foreclosure in another state, or if you're affirmatively sued by a prior owner who's trying to recover their excess equity or their surplus proceeds. So what this case said, you teed it up exactly right. The U.S. Supreme Court sent two cases back to the Supreme Court of Nebraska when the U.S. Supreme Court issued its opinion in Tyler back in May of last year. The Nebraska Supreme Court asked for supplemental briefs from the parties. They filed those around August of 2023. There was then an oral argument in February of 2024, and then the opinion issued in August. And the opinion, the two key things that it does, the first part of the opinion applies the reasoning of Tyler to Nebraska's tax sale process. And it determines that Tyler does apply to Nebraska tax sales. And then the second part of the opinion, which is kind of the blockbuster part, is it then decided who has to pay for the just compensation that's owed to the prior owner, and held the taxpayer or the tax lien investors in the case liable for that just compensation. So let's chat first about the first half of the opinion. As you explained, the Tyler case came out of Minnesota, and Minnesota's process for collecting delinquent taxes involved a forfeiture process after a lengthy, it's like 3 or 5 year process where the prior owners get a bunch of notices. They tack notice on the door, publish it in the newspaper. The title in Minnesota forfeited to the local county. It went to the county government. There was never an auction. There was never any bids or anything like that. The title, absolute title, just forfeited to the county. And then the county was responsible for fixing up the property, and then they could sell it at a profit and keep all the profits. In that case, Ms. Tyler owed something like $15,000 when the title forfeited. The county fixed up the property, brought it up to code, sold it for $40,000. So they kept about $25,000. So this forfeiture process, if you think about tax sales around the country, there are all kinds of different ways to collect delinquent taxes, all the way from a forfeiture process like Minnesota uses to a pure public auction where the title to the property is auctioned to the highest bidder. So if you think about it on a kind of continuum there, you can see how just losing your property, absolute title, that's a taking. I mean, you're truly, the county is truly taking your property, and they're not paying you anything for it. Whereas on a bid process, a true auction, there's a fair market value that's bid up, and then there's usually a method for returning the difference between what the county is owed. Well, what the case did there is it dealt with that first very clear issue, very clearly a forfeiture was a taking, but it didn't tell us what to do with all those cases in the middle. And the Nebraska process was one of those that fell in the middle. Nebraska has a process that was in play in 2015 under the 2015 statutes that allowed for once you bid and paid the back taxes that were owed plus some penalties and costs, then you would wait 3 years as the investor, and you could make a decision. You could either do a traditional foreclosure process through the courts, which would result in the auction of the property, or you could do an administrative process, which was to apply to the county treasurer for a tax deed. You had to send some notices and things like that. But once you'd done the notices and the deed was issued, you owned the property. There was no payment of any amounts to the prior owner. There was no bidding, no public auction in the sense of buying the property at fair market value. And so there was no surplus or equity that was generated to pay back to the prior owner. And what the Nebraska Supreme Court said is, even though the state process that was used in 2015 was not a true forfeiture like would happen in Minnesota, the Tyler versus Hennepin County opinion still applied, and it resulted in an unconstitutional taking because nobody was paying Mr. Fair the equity that he had in his home. So the court applied Tyler and said that this is a taking. Now, I keep talking about these 2015 tax sale statutes. That's because Nebraska has changed their statutes since then. They changed them in 2018, and also a bigger change just last year in 2023. So this opinion and applying Tyler to Nebraska's tax sale statute, it was applying it to a process that's already changed. And arguably, those changes were meant to address the effects of Tyler, and this issue should not pop up going forward. But the opinion didn't address the 2023 changes and just said for the process that was in place before 23, it results in an unconstitutional taking. So that's a lot of different tax sales that this could apply to, going all the way back. 2015 was involved in this case, but you could have tax sales 2019 through 2023, 4 years of tax sales that could be at issue here. So in those, the court said that just compensation is owed to the prior owner. And it moved to the second part of the opinion, which is who is supposed to pay that just compensation. And as you can imagine, everybody in the opinion started pointing fingers at each other, right? So the investors started saying that the county treasurer should have to pay the just compensation. And the county treasurer said, no, it's the investor. Both parties kind of were looking to the state attorney general as well. So saying that the state should have to pay the just compensation. And Mr. Fair, of course, was looking at all of them and said, I don't really care who pays me. I just need to be paid my just compensation. So the Nebraska Supreme Court, in the second part of the opinion, determined that the investor, the party who had actually applied for the tax deed and received the tax deed, was the one who had to pay for the just compensation, and said that it was that party who conducted the taking. And that's key here because generally when you think of constitutional violations, you think of a violation of due process or infringing on someone's speech. You think just about the government violating the Constitution, some sort of governmental actor. Well, if you're a private bidder, a private party comes in and bids at a tax sale, you're not a government agency. You don't have the same protections that a government agency has. You don't have the same immunities that a government agency has. You are solely separate from the government. Generally, you can't violate somebody's constitutional rights. But there are a couple provisions when you start looking at the takings analysis, and those provisions or those cases that are out there suggest that you can have a private state actor for the purposes of a taking. And the court in this case ultimately said that the investor effectively exercised a privilege created by the state in order to seize property. And so the investor was essentially moonlighting as a state actor. And so they could be liable for the just compensation. There were a couple of, it was almost as if the investors were acting jointly with the government entity to seize the property and ultimately take title to it. And so for that reason, the investor was the one who had to pay the just compensation. And the court ruled, the Nebraska Supreme Court ruled that the county, yes, played a part. It acted jointly with these investors, but the county only received the amount of back taxes and penalties and costs that were owed. The county didn't receive anything extra. It didn't cut into that excess or surplus equity that was in the property, so the county shouldn't have to be the one to pay it. And then the Supreme Court ruled that the state or the attorney general couldn't be liable. And this is an interesting piece of the opinion because it's kind of a little procedural quirk that's in the opinion. And this is really a way that we might see future cases come out a little bit differently. Early in the action that was brought by Mr. Fair, the attorney general had been dismissed from the proceedings. It was a consent dismissal, I believe, where all parties agreed the attorney general didn't need to be a party. The attorney general continued to play a part in the case when it was on appeal, because the attorney general is able to step in when there are constitutional cases and argue on the state's interests, but really wasn't a party. And that distinction mattered to the Supreme Court because the Supreme Court said, if the attorney general is not a party and the state's not a party, then we can't order them to be the one to pay this just compensation. And that's odd, right? Because it's the state legislature who passes the bills that set up this statutory process, and yet they're not responsible for the fact that a bidder just showed up and placed a bid, or a county treasurer just went through the deed application process and issued a tax deed. Both parties doing exactly what the statute says, exactly what the statute allows, and yet the state's not responsible for these other two parties. So that's a procedural quirk. I think that in future cases, if there are other copycat cases, having the attorney general in the case or the state in the case could mean a different result, could mean that the investor is not liable to pay for the just compensation. But only time's going to tell about whether or not we can shift that potential liability from investors to other parties. So, as I said early, this case applies really just in Nebraska, but you could see other parties try and make the same argument in other states that have either an interest rate bid down method or some sort of hybrid method that doesn't really create a surplus. But you could also see other parties in Nebraska bringing other cases, just like FAIR, maybe class actions even, to try and get just compensation for tax sales that had occurred over a long period of time, going back from the 2023 amendments. So we'll have to see what cases pop up. I'm sure there are going to be a host of different defenses that are going to be out there that just because of procedural reasons weren't raised in this case. So I don't want to suggest that any investor in Nebraska is dead on arrival when they get sued. There are probably other mechanisms that you can use to try and distinguish this case, but it's something that you got to really take seriously. And one of the reasons for that is Mr. Fair brought a case or brought his claim under a federal statute commonly called a 1983 claim, and it's a way to bring a civil case for violation of constitutional rights. And the statute of limitations for a claim like that, it really looks to state law to figure out what the statute of limitations is going to be. And I think in Nebraska has one of the longer statute of limitations applicable to these types of claims. It could be something like 4 years in Nebraska. So looking back from the 2023 amendments to the Nebraska statutes, you could have tax sales and liability for tax sales all the way back to 2020 if somebody were to bring a claim right now for a 2020 tax sale. So investors need to look at their portfolios, figure out how many properties they have where the delta between what they bid at the tax sale and what the property's worth or what they sold it for, and try to start calculating what that risk might be. Just so that you can have some sort of reserve set aside in case you get a copycat lawsuit like this. Now, this isn't the end of the road, though. The parties in the FAIR case, as well as the companion case called Naveen, they've still got 90 days to try and ask the United States Supreme Court to weigh in on this case. Obviously, it's a hot button issue. We've seen a lot of cases around the country applying Tyler, and the fact that this case had been remanded from the United States Supreme Court previously also is something that can be considered. I think that request to the Supreme Court to review the case would have to be filed somewhere around Thanksgiving. So this might not be the last that we hear of this case. If they don't seek review, then the case will be remanded in Nebraska into a trial court, and trial court will try to calculate what the just compensation is, because that wasn't something that this opinion decided. So we still don't have a lot of guidance on really how you get to that number, but we just know based on the opinion who has to pay that number. So again, it's an opinion. I think that if it's cabined to Nebraska, that's one thing. But if courts in other states start adopting that reasoning, it's something that we need to start focusing on and making sure that that we're taking as an industry taking these claims seriously.
Right. Well, I think that's let's say from an investor's perspective, the biggest fear is, will other states adopt, a similar stance, right? And then what hasn't been decided, like you mentioned, is okay, they're responsible for how many years, right? The statute of limitations, and then for how much, right? Per property, how is that going to be decided? None of that was. But I guess, so long story short, this is far from ever becoming a, hey, you got to pay this tomorrow, scenario. Who knows how long it'll take, to go down that road. But to kind of reiterate what you mentioned at the beginning, Nebraska's changed their statutes, right, with sales starting in 2024, right? And so as far as the length of exposure for Nebraska investors is somewhat limited. There are some states that haven't necessarily entirely changed their statute. and that exposure could still be ongoing, right? If they're not going to adopt something that creates a surplus that's available to previous owners. Well, I'm sure, Matt, we'll be talking about this again and again and again. And as the Tyler Hennepin fallout continues, as the Fair Naveen ruling fallout continues, I'm sure we'll talk again. Is there anything else that we need investors to kind of know at this point?
No, I think the key takeaway here is this is a sea change in the law that is going to affect Nebraska tax sale investors directly, but it could indirectly impact other tax sale investors in other states. And so the second you get a whiff of a claim like this in your state, if it's against you or against one of your competitors or colleagues, is to make sure you keep your finger on the pulse and follow it, because it could be that this expands to other states, but it could also be that Nebraska is on an island by itself, just based on the reasoning and the procedural quirk I mentioned. So only time will tell, but it's something that needs to be on everybody's radar.
Got it. Well, Matt, I greatly appreciate you hopping on and getting us up to speed and filling in some of the gaps. And I guess hopefully it didn't freak out anybody too much. For the listeners, if you have any questions on this, or you're wondering kind of what your exposure is in Nebraska or other states, feel free to reach out to Matt. His contact information should be in the email that you received reference to this episode. If not, you can reach out to us at Tax Sale Resources. We'll get you in touch with Matt from there. Well, thanks again, Matt. I'm sure we'll talk again soon.
All right. Sounds good. Thanks.
All right. Take care, everybody.